All right, we're at 1:31, and I want to make sure we have plenty of time for our presenter and all the questions. So I'm going to keep admitting people, Elizabeth and Tanya. So if I pause for a second, I'm just getting distracted by all the people trying to get in. Hi, everybody. Welcome. I have a little bit of housekeeping before we start. Welcome to today's will and estate planning session sponsored by Chicago Title. The Realtor Foundation has long believed in providing my board members with the tools to prepare for your futures. And we have lost many long-time and influential realtors who had no plan in place. And that fact was devastating both for their families and for their business. And so this has always been a passion of ours to bring this sort of education to members. There are many charitable opportunities available to you as you develop the best plan for you and your family. If you'd like information about how to include the Realtor Foundation in your plans, please reach out to me for some more information. Before we get started, do you have a couple little housekeeping? Just make sure that you stay muted unless you're unmuting for a quick question. At any time, if you have a question during the webinar, feel free to submit your question in the chat. And I will interrupt our speaker, Elizabeth, with questions as she goes along, or we'll keep some of those to the end. So make sure you're putting those into the chat. As time allows, we'll make sure we do as many questions as possible. We're recording today's webinar and we'll share the link after tomorrow afternoon session. Now, I am pleased to thank our sponsor, Chicago Title, and Tanya Ott is with us today. So Tanya, I'm gonna stop sharing and then you screen share.
Fantastic. Thank you so much. Well, welcome. Good afternoon, everyone. I'm going to take just a minute or two and just kind of do a quick little promo with regard to a new program that we've rolled out. So I've got a whole 50-second video to capture your attention here for just a moment. So I am going to share that. So here we go. Everybody see my screen okay? In here, start, track, close. Can I get a thumbs up? Oh, wait a minute. It would help if I hit the button share. Okay, everybody see that okay? Fantastic. Well, here we go.
Tanya, is there audio with that video?
Not really. There's a little music, but it's All right, so just very briefly with regard to that, so we've just rolled out our In Here platform, and ultimately what that is, it's actually kind of a four-part series as far as a digital platform. The first piece or part of it is our Start Safe platform, which is how we provide wire instructions securely directly to buyers. The second piece of the platform is In Here, and it's a transaction management. So for those of you that have any transactions in process with us currently, we rolled it out maybe a week or two ago. So you've started to see emails that invite you to explore your order in here. And ultimately, probably the two biggest pieces of it is it allows you to receive push notifications on your cell phone as to various milestones within a transaction. So you'll see that title work was ordered or closing was scheduled as a push notification on your phone. Preliminary figures have been sent to the lender for approval. So it lets you know, hey, yes, we've got closing instructions. We're communicating with the lender. We've got it to them. And then final CD approved. So it kind of pushes things out as notifications as opposed to just emails. Now, it doesn't replace how we currently communicate with you. So if you're familiar with our systems and processes, those aren't going away. This is just kind of another added benefit, but it also allows you to indefinitely store information relative to the transaction. So I know inevitably, folks, we get a lot of phone calls after the first of the year with someone looking for a signed closing statement so they can do their taxes, right? We're kind of in that season right now. But you can have all of your documents relative to your transactions with Chicago Title in one single portal, and those documents live in there forever. So it's a nice, convenient place to go to find information without trying to dig through old emails and that sort of thing. So that is the extent of my hopefully 3-minute or less commercial, and I'll be excited to kind of join in a little more tomorrow on the title side of the estates and wills and how that impacts your closing. So with that, I will go back on mute. If anyone has any questions for me, certainly reach out after the program and I'll be happy to connect and get you more information on it here. Thanks so much.
Thanks, Tanya. Okay, I am happy to introduce today's speaker, Elizabeth Schlueter. In 1992, Elizabeth Schlueter graduated from McKinney School of Law in Indianapolis and began serving families in the area of wills, trusts, guardianships, and estate settlement. Her legal career began in a small law firm in LaGrange and moved to Fort Wayne, where she served as trust officer and associate trust legal counsel for what is now known as J.P. Morgan Chase. As she continued with the bank, she had the opportunity to work in every area of fiduciary service, including tax and estate administration. Her banking career culminated as national head of wealth advisory services. Her responsibilities included leading a team of professionals located throughout the United States who worked with clients to create and implement estate plans and structures to ensure a family's financial success was maintained. This experience allowed her to develop the trust, estate, and tax technical skills needed to provide insightful planning execution for her clients. Her ability to connect with people and explain complex concepts simply allows her to translate those skills into service for families all across the country. Her most recent prior experience as the Chief Family Office Strategist for Oxford Financial Group and the Chief Fiduciary Officer of the Trust Company of Oxford allowed her continue her passion to help clients fulfill their financial legacy for their families and communities. In addition to her work with clients, Elizabeth has shared her knowledge in several noted publications, including the New York Times, the Wall Street Journal, Financial Advisor, Bloomberg News, and Forbes.com. She's also an accomplished speaker on will and trust and planning issues, and so I'm sure she's going to be a fantastic speaker for us today. So Elizabeth, take it away.
Well, thank you very much, Gabby. I really appreciate that glowing introduction, and frankly, way too long. And as you all can tell from when I graduated, I've been doing this for a while. I am going to attempt to share my screen. Let's see. How do we do that? And I will tell you, technology is not my best friend. So let's see. Here we go. Are we there?
Yep, looks great.
Perfect. So what we're going to talk about today is just some information that I think really everybody over the age of 18 should know, and unfortunately doesn't. And so what we wanted to talk about is estate planning. And I have a lot of people who come to me and say, well, you know, I understand why when you get older and your family's kind of grown, why you would think about that, but why would a younger person need to do that? And so we're going to talk a little bit about why this is important for everyone as we go through this. And I want to point out that what's really important here is the planning component. So what this is really about is enabling you to make decisions regarding what happens with both you and your family during your life if you become incapacitated, and then after your life as your assets transfer. If you don't plan, unfortunately, the state has a plan built in for you. Most of us aren't really comfortable with the plan that the state's developed. So we want to make sure that we're the ones that have the opportunity to kind of do that. So the first thing we're going to talk about is planning for your disability. And what this is, it's an opportunity for you to say, if there is a point in your life when you are not able to make good decisions for yourself, either financially or with your health care, that you get to determine who makes those decisions for you. Those decisions are, those documents are called powers of attorney, and they are in existence during your life. That's one thing I think it's really important for you to know. Powers of attorney only have effect while the person who created them is still living. The minute that person passes away, the authority under that power of attorney terminates, except in a couple of special situations that we're going to talk about in a minute. So there are two basic types of powers of attorney. There's what's called a general durable power of attorney, and that governs your financial affairs. And then there's what's called an appointment of healthcare representative in Indiana, which is the document that allows you to say who you want to make medical decisions for you in the event you're not able to either make them because you lack capacity or because you can't communicate. So in either of those two situations. There are a couple of other documents that can come into play around incapacity. The first one is trusteeship. So if you've created a trust during your life, that trustee might be able to assume financial responsibility in certain situations. And the last, and I think for most of the people that I talk with, the least desirable is a guardianship. And you can have a guardianship of your person, so that's of my body and my medical decisions, or a guardianship of the estate, which is my assets. And some of the issues around guardianships, that's kind of the plan that's in effect if you don't make a plan for yourself, is that the court is the entity that appoints that guardian. And that guardian is appointed, because it's appointed by the court, it has to be overseen by the court. So not only is it made by someone who usually doesn't know you very well, it's also a very public proceeding. And because the court has a responsibility, since it's appointed that person, it wants to get regular reports that that person is doing their job. And so because of that, then information that's normally fairly private, for example, your financial information, becomes part of the public record, because that guardian is going to have to file a report with the court saying what's happened with your finances. Most of the people that I talk to are really uncomfortable with that process and would really prefer that they and their loved ones not be subject to that. And that's why it's important to do the planning and do the powers of attorney that we talked about just a few minutes ago. The other thing that's important about that I want you to think about is, most of us think about these things when they're unfortunately getting to be my age and hopefully a little older. But it really is important that everyone over the age of 18 especially have these powers of attorney in place. And I'm going to give you a little example. My daughter had a very serious bicycle accident when she was 24. She was hit by an SUV, and it's so serious that she was hospitalized for a long time and was in danger for a long time. Silly me, I kept thinking, oh, we'll do it. I never got it done. And so she was in this accident. And because I didn't have an appointment of healthcare representative for her, I didn't have the ability to ask questions of her doctor, get medical information, even theoretically be in the room when the physician was speaking with her. As a result of that, there was an undiagnosed issue with her that we didn't even know she had, because we had no access to her medical records. And because it involved a traumatic brain injury, she didn't have the capacity to know that either. And so we went for an entire year without treating her for that specific situation, because no one who had capacity really understood that was a situation. So if you have young adults in your life, anyone over the age of 18, kids going off to college, kids that have just graduated, I highly recommend that you talk to someone about putting in place a durable power of attorney for their finances, so that you can take over and take care of things if there's a situation, and especially an appointment of medical representatives. So if they're in a situation where they can't make a medical decision for themselves, you can do that for them. But that's also important for you, because as medical technology and medical science have advanced, it's more and more likely that there's going to be a time in your life where you don't have the ability to make those decisions, before you pass away. And so it's really important that you be the author of who that is going to be in your life. So let's talk a little more in particular about those. So in the appointment of healthcare representative, that person really has the ability to step into your shoes from a medical perspective. So they're going to make decisions regarding whether to get medical health care, refuse medical health care, or withdraw medical health care. And this is normally incorporated into a power of attorney type document. It can include a living will declaration. And I noticed we have a typo on our slide. Sorry about that. It's including brain death, not brain dean, and persistent vegetative state planning. And what it allows you to do is it allows you to incorporate a living will. A living will is a separate document, and I'd like to take just a minute and talk about that, if that's okay. What a living will does is it's a statement of intention. It's not a contract. And what it says is, if I sign the living will, it states that I do not want extraordinary medical measures used to keep my physical remains functioning if a team of medical providers has determined that I am no longer sentient and I don't have brainstem activity. And that's what people talk about when they use the term, when it's time to pull the plug or those kinds of things. It's a statement that at that point, if your physical remains are being kept functioning through extraordinary medical situations, that at that point, you don't want those situations to continue. That document can either stand on its own or it can be incorporated into your appointment of healthcare representative. It can also include information on organ donation and donation of your physical remains for study, for medical science, or medical education. One interesting thing to note is that with an appointment of healthcare representative, it only becomes effective if you are not able, either because of lack of capacity or because of communication issues, to communicate your wishes regarding your healthcare. So you cannot give away the right to make medical decisions for yourself as long as you have that capacity. That's a little different than a general durable power of attorney. A general durable power of attorney is a document which states that you are giving the right to perform a service around your financial situation to someone else. And I would imagine that most of you are pretty familiar with powers of attorney, because I know one of the areas where we get lots of requests to do them is around real estate transactions. And a lot of times people will use a limited power of attorney to give someone else the authority to execute a transaction for them in regards to buying or selling a house, especially if they're moving in town or out of town and changing states, and only one person in the relationship can show up, so the other person gets power of attorney in order to complete that transaction. The document I'm talking about today for each of you is a little broader than that. And what it's designed to do is it's designed to say that the person that you've named in this document has the ability to step into your financial shoes. So whereas that real estate transaction document is a limited power of attorney, what I'm talking about is a general durable power of attorney. Now, there's a couple of things you need to think about with that. The first is, when does that document become effective? Because unlike your appointment of healthcare representative, you have the right to give away the right to make those financial decisions even when you have capacity. But most of my clients who are younger, and by younger in my world, that means 85 and below. So most of us would qualify for that. Determine that the best time for that document to become effective for them is in fact when they are unable to make those decisions. So we call that a springing general durable power of attorney, because it only springs into action. Remember, we're lawyers, we're not exactly creative people. It springs into action when we are incapacitated. And we have to outline in the document how that incapacity is captured for the person who's reading the document. So most of the documents that we have would say, when my physician or a physician who has treated me is willing to say in writing that I am no longer able to make good financial decisions for myself, then that writing gets attached to that power of attorney. And when it's attached, then that power of attorney becomes effective. Okay. Now, the other important thing to know about that is that because we want it to be effective, when we are incapacitated, it has to be a durable power of attorney, which means it has to survive that incapacity. But remember, it does not survive death unless there is one time when it can, and that is there are special provisions that allow for a power of attorney to create a funeral plan for you and work with the funeral home after you've passed away in order to transfer your wishes in regards to the disposition of your remains once you've passed away. But that's really the only instance where a power of attorney would survive the person who's creating it passing away. So the other important thing about that we're going to talk a little bit more about tomorrow is that what that means is if you're in the middle of a transaction and someone is acting on someone's behalf as a power of attorney, theoretically that power of attorney terminates at death, and that can cause a problem in terms of the completion of your transaction. But we'll talk about that a little bit more tomorrow. So it's really important for really every person over the age of 18 to have a power of attorney naming who they want to make medical decisions if they can't, and a healthcare representative form saying who they want to make medical decisions if they can't. I included a slide on guardianships. We've talked about that a little bit. I'm hoping you'll all do your planning, so that won't be necessary. So we're going to kind of pass over that for a minute. The next thing we're going to talk about is called a standby guardianship. Now, this is a little different. If any of you have children who are under the age of 18, one of the things I'm sure you struggled with is if something would happen to you and that child's other parents, who would take care of that children in that situation? Hopefully most of you have had that discussion and made some decisions and executed some documents we're going to talk about in a minute that kind of go through what that process is. But what we've found is that there's a period of time between when maybe an extraordinary event happened, an accident, something like that, and when the document that you've already created might come into place. And so what our legislature did is they allow us now to create what's called a standby guardianship form. And what it really is a temporary guardianship of your minor children. So it allows you to create this document and name who would pick your child up from childcare or from school or soccer practice, or if they are unfortunately involved in the accident, from the hospital or the scene of the accident, and they have full legal authority to then take care of your child until the people that you want to permanently do that for you, if you're not able to, have the ability to get there. So this is kind of that short-term bridge that my husband and I, we have 4 daughters, and if when they were younger, because they are now older, but if when they were younger, if we would have had an accident, it would have allowed us to name someone who could pick up and take care of our children until our family that might be from out of state had an opportunity to get there and take more permanent responsibility for them. So you can name the same people in this document that you've named to take care of your children on a more permanent basis if it's a more permanent situation, or you can name people that might be geographically a little closer, because this is really designed to happen when there's some kind of an emergency situation and we don't have an ability to go through a normal process. So highly recommend if you have minor children or if you have a mentally or physically incapacitated adult, same rules kind of apply, that you create this structure for them. So there is someone who can take over immediately in a situation until maybe the more permanent person has an opportunity to join you. So now, unfortunately, we're transferring from your lifetime and taking care of you to how we transfer the things that you have grown and protected during your life once you're gone. And so what you see is there's a variety of ways that those assets can transfer when you die. The first is they can transfer by title. They can transfer during your life by gift, and that's by you giving them away. The third is in certain assets, you have the right to name a beneficiary, life insurance and retirement plans, those kinds of things. Pay on death or transfer on death designations. It used to be we could really only do those with checking and savings accounts. Now we can do that with brokerage type and investment type accounts with transfer on death designations, and we can even do that in certain situations with real estate, which again we'll talk a little bit more about tomorrow. But you can name a person in that kind of document to receive your real estate when you pass away. If you don't name anyone and you don't have any joint ownership on your assets, the state does create a transfer plan for you called intestate succession. I have included a couple of slides that kind of go through what that looks like so that you can get a feel for that. And for most people, that plan is not ideal, and we'll talk a little bit more about that in a minute. You can create a last will and testament that transfers any asset that you own yourself as you designate in that document. You can create a trust, and that can be in conjunction with your last will and testament, or it can be separate from that. That's a document that creates a structure that actually survives your death because it creates its own entity. It's kind of like when you create a company. Your company doesn't die when you die, and neither does your trust necessarily. And then there's custodial accounts that we use in certain situations to transfer assets to minors. So let's talk a little bit more in depth about those. And I am trying to move pretty quickly because I want to make sure I give you enough information, but give you time to answer some questions. And then if there is anything that anyone wants to talk about that might be a little more fact specific and you don't necessarily want to share with the group, please feel free to shoot me a note or call me, or I'm happy to talk about any of that with you offline. So let's talk about transfers by title. So the way that that happens is joint ownership. And what that does is it's when more than one person owns that property. Now that doesn't mean that that person necessarily participated in the equity necessary to acquire that property. It just means that the people that own it have agreed they own it together. And there's a couple different ways to do that. One of the things that I think it's most confusing for people in the real estate business and for people buying and selling property is the difference between these designations. So I am going to spend a little bit of time on that. There's a designation, the most basic, called tenants by the entireties. And in Indiana, any property that you own as a husband and a wife or a husband and a spouse is considered tenants by the entireties. What that means is that both people in that transaction own 100% of that property. And theoretically, no one in that relationship can transfer, sell, anything with that property without the consent of the other person. The other thing that means, though, is that in a creditor situation, for your creditors outside that property, they don't have the right to take that property away in order to satisfy a liability you have to them. So it's very protected property. It's probably the most protected designation that we have. The next is similar to tenants by the entireties, but it's when every person that's listed owns 100% theoretically of that property with rights of survivorship. And what that means is that no one has a designated piece of that property. Everybody kind of owns 100% of that property together, and whoever is the survivor takes ownership. So I have 3 brothers and I have a husband. I own my house as tenants by the entireties with my husband. I might own real rental property with my 3 brothers with joint rights of survivorship. if that's the case and I die, my husband owns our home, but my remaining 3 brothers own the rental property. And it passes automatically by law the minute that I die. Okay? Very important to understand that. Happens automatically. Now you have to file some paperwork with the recorder so that the recorder knows that I died and knows that my husband is the surviving owner of our tenant by the entirety's property, and knows that my 3 brothers are the surviving owners of our joint property with rights of survivorship. But by law, that transfer occurred automatically. There's a third way to own property called tenants in common. It's a little different. Tenants in common, if I owned my property with my brothers as tenants in common, we would each own 25% of that property. When I died, if I wanted to, I can leave my 25% to anyone I want. So I could leave my 25% to my husband, or I could leave my 25% to my children, or I could go ahead and leave my 25% to my 3 brothers, but I don't have to. It's divisible. So that's a really important distinction. Now, does that mean if we have 100 acres of land somewhere and I die, that 25 acres just gets portioned off and passed to whoever I leave it to? No, there's some other things that have to happen if I need to identify which 25 acres are mine. But again, we can talk about that a little bit more as we go through. So that's the ways you can own property together. Now, another option that we have available today is called a transfer on death designation. And what this allows me to do is if I own property myself and I want it to go to a certain person, but not until I die, I want to use it through my life, I can do what's called a transfer on death deed. And my transfer on death deed allows me to say, I own the property through my life, and that means I can change anything about it, including selling my property if I want to. But if I own this property when I die, it goes to the person or persons that I've designated. Okay? Now, it does not affect my ability to do anything I want through my life, including I can take off the transfer on death designation anytime that I want to, prior to the time that I'm incapacitated or I pass away. So it's not something that's automatic in terms of, woohoo, I'm on the deed, I get the property, it's absolutely mine. I still have to be nice to Aunt Betty if I want to do that, because she can change her mind and she can take me off anytime she wants to. Okay? And remember, that type of property, just for you individually, because that's what we're talking about today, is your plan is you can do that on a brokerage account. You can do it on your real estate that you own in your own name. You can do it on your bank accounts. So really any asset that you have, if you want, you can transfer it that way. All right, so let's talk about what happens when you don't have a plan. And this is a problem, I think, for a lot of people. Most of us assume that if we're married and have children and we die and we don't have a will and we haven't designated ownership in any of the ways we've talked about already today, that property just passes to our spouse, and if our spouse isn't living, then to our children. And unfortunately, that is not the case. So the way that this works is, first of all, it does only apply to property that is in the person who's passed away's sole name. So again, remember, we talked about if I own something jointly with someone else, and it's not as a tenants in common, but it's joint with rights of survivorship, then that asset goes to those remaining owners. Okay? But anything I own on my own, or any percentage that I own of property as tenants in common, passes under this intestate succession rule if I haven't created another way for it to pass. And what happens that I think is kind of surprising to people is that if you're married and have children, no matter what age your children are, when you pass away without a will, anything that you own alone without a beneficiary designation and not without joint ownership passes 1/2 to your spouse and the other half to your children, no matter what age they are. And I will tell you, some of the most uncomfortable conversations I've ever had in my whole career is having to tell someone who just lost their spouse through a very unfortunate illness or accident that, and the other person owned the house because they had good credit and they could get the better mortgage, and they just never got around to retitling the property, that now their home is owned half by them and half by their 5 and 3-year-old. That does not work out very well. Because remember, when you're a minor, you can't own any property in Indiana. So then we have to get one of those guardianships that we talked about that are public and expensive and court appointed, so the court determines who that is. So it can be a really uncomfortable situation for people. So especially if you're in a relationship or if you have children, you really want to make sure that you have a valid last will and testament in place to make sure that people that you want to inherit your property are in fact the people that will inherit that property. I have included other situations in here that you can kind of trace down through if you want to see, well, what if this happens or what if this happens? But what I'm hoping the overall lesson is that we want to avoid intestate succession whenever possible. So that brings us to, well, then what do we do instead? And for most of us, that means that we need to create a valid last will and testament. And what a valid last will and testament does is a couple of things. First of all, it allows you to name who you want to be responsible to make sure that the things that you want done actually end up happening. So it allows you to name what's called a personal representative. We used to call them executors and executrixes, but the more modern word is personal representative. And then it allows you to say, personal representative, your job is to take the assets that I have in my name and pass them out to the people I've said in this will should get them when I die. And so it allows you to name who you're going to receive your property and how they're going to receive it when you die. The other really important thing is that if you do still have minor children, it allows you to name who you would want to be their guardian on a more permanent basis if something were to happen to you and they needed that kind of protection. And it allows you to name who is the guardian for their person, so to make decisions about their physical care, where they live, where they go to school, all those kinds of things. And then there's a guardian of the estate, can be the same, can be different depending on what works best for you. But the guardian of the estate is the person that says, okay, these are the things we're going to pay for. This is how we're going to do this, and this is how we're going to support your minor children until they reach the age of majority. So really important if you have children under the age of 18 to have those guardianship provisions in place. Okay. Then the last document I want to talk about briefly, and then we'll turn it over for a couple of questions, is trusts. And I know a lot of you have probably heard about trusts from some of the more, let's say, infamous situations where there are people that have been left lots of money and they seem to get in a very extravagant lifestyle. And so most of us think, oh, that doesn't apply to us. That's not really, that we're not trust people. But this is what I want you to think about. Trusts were actually created 400 years before the first death tax was put in place. So before the first tax that would have required a trust, trusts were in existence. And if I was you, I'd say, well, why? This is why. Trusts were created as a way for you to protect people that you want to leave assets to beyond your natural lifespan, because the trust can exist after you're gone. So I talk to a lot of clients about trust, especially when they have younger children, because the trust can take the assets that they have and want to put into place for their children and can ensure that not only will it protect them, until they're 18, but they can even protect them beyond that. So most of my clients are a little uncomfortable saying that their children are going to receive 100% of whatever's left of their inheritance when they're 18 years old. Maybe 25 is a better number, or maybe 30, or maybe dividing it up. Half 25, half 30 is a better situation in their mind. A trust allows them to create that entity that lasts beyond that child's 18th birthday to continue to protect that child, to help guide that child make good financial decisions, to teach that child how to make good financial decisions. And in the case of kind of breaking up that ultimate distribution, sometimes it's to give that child a second and third chance to make a better financial situation and decision for themselves at that point. So creating that trust isn't about tax planning or about saving on income taxes and death taxes. It's about creating a structure that protects their children, your children, for longer than you can under a traditional last will and testament. And so that's why a lot of clients that I talk to today still choose to utilize a trust. A trust can also protect your children who are technically adults, and I say that because I have children between the ages of 22 and 32, and technically they're adults. I wouldn't say they always make the best adult-like decisions. So it would allow me to protect them from some bad decisions. It protects from creditor invasion. It can protect from a choice in spouse that doesn't end up being what we all would have hoped it was going to be. So it can protect against disillusion. It can protect against, a lot of children that I see that lose their parents very early in their life can have some struggles, especially around addiction issues, all different kinds of addictions, and it can protect against that. It can protect against a lot of things that if you were still here, you would protect against, but because you're not, we need to create another way to do that. And so a trust can allow for that protection. So that's a lot of what trust can do. Now you can create a trust either in your will or you can create the trust during your life. Inter vivos means during life, and testamentary means through your will. And that really depends on your personal situation and what you're most comfortable with. And then the other thing I want you to understand a little bit before we talk more tomorrow is the difference between a trust that can be changed, so that's a revocable trust, and a trust that can't be changed, and that's an irrevocable trust. Most of the time we only use an irrevocable trust when we're making a gift to somebody. We use a revocable trust because we can change it to the point of we can even get rid of it anytime we want to, as long as the person who created it is still alive and has capacity. So most of the trusts you're going to run into are going to be revocable trusts, but you need to understand the difference between the two. And then we talked a little bit about the benefits, when it might be a good idea, and what's important to consider. The other important decision is who to make your trustee. You want to make sure that's someone that you really trust. It can be an entity, it can be a person, but you really want to use someone that you think has expertise and knows your family. And then the last is you want to make sure that you have capacity. And the important thing about that is that you need to know who you are, who your family is, and what you have in order to validly execute these documents. And I think that's pretty much it for my comments today. Gabby, I don't know if we have any questions or if there's anything else that anyone would like to talk about, but happy to answer anything.
That was great. I'm sure you, there were a lot of nodding heads. If you had seen everybody's faces and we were room together, you would have seen lots of nodding heads talking about those protections in place for young adults. And those, I certainly probably would have needed some of those at that age too. We have one question about, I think it speaks to that, setting up our young adult children for success in terms of having that health proxy documents and last will and testaments in place. What might a young adult, unmarried, no children, and not many assets expect in terms of cost of putting that together?
Well, again, that's going to depend a little bit on how they choose to do that. So in this age of technology, there are options over the internet to put some of these documents together. Full disclosure, I am not a fan. And that is because there are intricacies in state law that we need to make sure are met when these documents are put in place. And some of them are as simple as how many people you have witness a document versus whether a document should be notarized. And I know you all understand the importance of those things because as you go through closings, there's things that have to be notarized and there's things that have to be witnessed. And part of what we look to our wonderful friends at the title company to do is to know all of that and be able to work through all of that so that those documents are appropriately executed. That's the same kind of issue that you sometimes get when you create one of those documents through one of the providers over the internet. I think that most of my colleagues, I know especially in our office, when we have someone who we've done some other work for and they have young adult children, we do a substantial break on cost in order to make sure that those children are in fact protected. So I don't necessarily feel comfortable saying a number, but I would say if you have an attorney that you work with regularly, I think most of us will work with you and work with that young adult because we'd rather see them have the documents in place and maybe not pay us a little more than not do the documents because of cost. So cost should not be an issue in terms of that. And I know if it is with your provider, call us and we'll get it done because we think it's important.
I know that a lot of these topics are difficult family conversations to have. How would you recommend starting that conversation if you are worried that maybe your parents don't have the proper documentation in place, or maybe you and your siblings aren't necessarily on the same page about what mom or dad's expectations are? How would you start that conversation with your family?
Well, I think a great way to start is to say, hey, I met with a lawyer and went through the process of creating a plan for myself around what would happen if something happened to me, both to make sure that I had people in place to take care of decisions for me if I was still here, and then to make sure that things were protected for my family when I was gone. I think that's a great way to start because then I think you have a very valid way of saying, just wondering, have you had an opportunity to have that conversation with somebody? So I think that's a great way to start. The other thing I think is very valid is that if there isn't something in place, especially for our parents, and we have siblings, it can get really damaging to your family situation if everyone doesn't understand what mom and dad wanted to have happen when something happened to them. And we see families all the time who break apart. Thanksgiving is ruined, we don't have holidays together anymore, our kids don't have relationships with their cousins and their aunts and uncles anymore, all because no one sat down ahead of time and kind of said, Mom and Dad, what do you want to have happen? Who do you expect to do things? Have you had an opportunity to put that in writing somewhere so that we all know? So I think it's, as long as you come from a place of concern and caring when you have that conversation, I think there are ways to do that where, again, it's an open-ended question and it's not accusatory and it comes from a place of we want to make sure that our family continues to have this great relationship that we have today.
That's great. How often should someone be reviewing their documents?
So we have a program in place where about every 5 years we send a letter to folks and say, hey, we're here. And if anything's changed in your life, maybe we should sit down. So anytime there's a change in your family, sometimes that's prompted by a wedding or unfortunately a divorce or the birth of new children or children reaching certain ages. Changes in job can be a big reason to kind of look at things a little differently because assets change then, IRAs, 401ks become IRAs and all those kinds of things. And then there are changes in the law. So one of the things that doesn't affect a lot of people in Indiana, but there is a tax called estate and gift tax. It's assessed on individuals that have, in our opinion, pretty significant net worths. Right now it's $11.7 million per person. So frankly, most of our clients aren't concerned about that, but the president is talking about lowering the amount of that tax down to potentially $3.5 million. And there are a lot more people in central Indiana who have $3.5 million than have $11.7 million. So there could be some changes in the law that would also prompt you to just, make a quick call. A lot of us will sit down and have a conversation with you if we've done your other documents, just to kind of go over them for little to no cost, just to make sure there's nothing that should be updated or anything that should be changed. So I'd say 5 to 7 years at a minimum.
Okay. This question, I think you guys are going to cover tomorrow, but why would somebody purchase real estate with a trust?
Okay, so we are going to talk about that tomorrow because one of the important things to know is that when you're helping a client here in Indiana, especially purchase real estate out of state, there are two structures that it's highly advantageous for them to use to do that. One is a trust. One could be a limited liability company or partnership, some kind of corporate structure. And the reason you want to do that is that individuals who own real property in more than one state and die owning that in their own names have to open an estate in each of those states. And in some states in the United States, for example, the state of Florida, there isn't any income tax. Well, I don't know about all of you, but I don't think any of you would not realize that Florida has to be making money somewhere. One of the places Florida makes up for no income tax is fees that it charges for the transfer of property and for the transfer of that property, especially at death. So when I have a client who lives in Indiana and is an Indiana resident and wants to buy a second home in Florida, we always create a trust for the trust to buy that home, because when that person dies, remember we talked about that trust continues to exist. And so when that person dies, we don't have to create a probate estate in Florida because the trust is still in existence. So nothing has terminated. The new trustee owns that property as part of the trust estate, and we don't have to create a second probate estate. Now we can talk about that a little bit more tomorrow, but that's a quick answer.
That's perfect. You and Tanya are going to join us tomorrow at the same time at 1:30 on Zoom. It should be the same link, but you should get another reminder tomorrow to join us. And you guys are going to be talking about how all of this impacts real estate and things that might come up that you might see with your clients or in a transaction. I think it's going to be a really great conversation between the two of you, so make sure that you join us. Elizabeth, how can our participants get in touch with you?
Well, I think we shamelessly put, yes, we did. We shamelessly put our contact information on the slides. So we are happy to answer any follow-up questions, talk with any of you about anything that could be helpful. And if you would like help creating your plan, we would love to talk with you.
Thank you, Elizabeth, so much for joining us this afternoon. We'll see you again tomorrow. If anybody has any questions, you can also reach out to me and I'll get those passed along to Elizabeth as well.
Thank
you
you
so much.